Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondaq webinar in association with SRP-Legal. Today's webinar will provide a high-level review of the legal developments concerning technology law, including data protection and privacy law, fintech and AI law. We are joined today by an excellent panel. Chigdem Ongun is the founder and managing partner of the SRP-Legal. Dr. Ongun has extensive experience in technology, media and communication law, financial technologies, e-commerce and corporate law, competition law and data protection, and privacy law and regulatory policies. Dr. Ongun is the writer of the book Personal Data Protection Law and FinTech Sector's Player Competition with Banks section of the book Applied Competition Law. Dr. Ongun is the president of Data Protection and Technology Law Working Group of Turkish Industry and Businessmen Association and executive board member of Blockchain Turkey Platform, founding member and ethics committee member of Women in Technology Association. And we are also joined by Günçer Çakır. Günçer is head of legal ING in Turkey. Günçer joined ING in Turkey in 2018 as executive vice president, and she's been heading legal at ING in Turkey since then. She is a board member at ING Leasing Turkey. Before I hand over to our panel, here is how you can get involved in today's event. You have the opportunity to submit questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we'll address as many as possible during our Q&A session at the end of today's presentation. It's now my pleasure to hand you over to our speakers to begin today's webinar. Thank you.
Hello, everybody. Thank you, Dan. I'd like to welcome you all. As SRP Legal, we are honored to host this webinar, and I will be moderating the webinar as well today. I'd like to also welcome my guest, my dear friend, and my distinguished colleague, Günçer. Yes,
Hello.
Thank you very much for joining us today, Günçer.
My pleasure.
We said tech law made simple. So today we will be discussing the main tech law issues such as data protection and data privacy, fintech law, and also the legal tech area and how much we use them and made them the law practice simple. I will be discussing the main challenges from a broader perspective. Then I will request Günçer to evaluate the issues from the banking industry perspective. Yes, let's start with the Turkish Personal Data Protection Law and General Data Protection Law regulation comparison. In a nutshell, the Personal Data Protection Law in Turkey, which I will refer as PDP law, regulates the processing and protection of personal data in Turkey, and this law has entered into force in 2016 when the 9546 EC directive was not yet repealed by the GDPR. Therefore, the PDP law is based on 9546 EC directive, which clearly fails to satisfy a certain level of protection of personal data and regulation of the personal data processing, given the today's intense digital services and practices. However, since the GDPR has entered into force, the Turkish Personal Data Protection Board has issued various announcements and decisions for sizing a closer reciprocity with the GDPR. With the support of the board's approach, we provide our services regarding the personal data protection in compliance with the objectives and the soul of the GDPR as much as possible. A very important development took place in the last few weeks that I really would like to mention. The new objectives regarding the protection of the personal data are announced through the justice reform in the meeting of the Human Rights Action Plan by the Presidency of the Turkish Republic. The most exciting one of these objectives is about adaptation of the personal data protection law to the standards of the European Union. in order to provide the protection of individual privacy in the personal data processing. I find this objective very valuable in terms of both legislative achievements and improving the practicality of the personal data protection. As I said, the PDP law is prepared based on the EC Directive 95/46, which was then still not revoked by the GDPR. As of today, there are certain subjects that are regularly in the PDP law, while they clearly take place in GDPR. Let me give some details about these. For example, under GDPR, the notions of privacy by design and privacy by default is regulated. For those who are not familiar with these terms, privacy by the means of privacy by design, establishing privacy by the way of technological design, while privacy by default can be defined as the privacy established from the beginning of the relative service. Under the GDPR, data protection impact assessment is also obligatory for the certain types of personal data processing activities. Some examples of these types of the personal data processing activities are, for example, scoring, profiling, automatic decisions which led to legal consequences for those impacted, systematic monitoring, etc. So these specific regulations, which I just mentioned, do not have a reciprocal regulation under the PDP law legislation. The most important thing, today's challenge in Turkey and between the other countries, I guess, is the cross-border transfer of the data. Under the PDP legislation, the transfer of personal data abroad is regulated through a complexity of various methods, which may require an explicit consent. By saying transfer to abroad, I mean every single transfer outside of Turkey, regardless of the destination, whether in the EU or other regions. In practice, this means even the use of digital services, which the servers located abroad, includes the cross-border transfer of the data. Let us think the use of Gmail. As of today, every single person in Turkey who use Gmail services are actually having their personal data transferred abroad by Google. In fact, there are several specific decisions of the Turkish Data Protection Board that clearly indicate that the data controllers who have servers outside of Turkey, like Google, Amazon, etc., these service providers using cloud technologies are transferring personal data abroad. Needless to say, this is a very challenging situation to handle for a multinational company in terms of their compliance with the PDP law. Of course, this is not a challenging situation for only a multinational company, for everybody, because we all start using those kind of cloud services. As we turn to GDPR, a notion of cross-border transfer of the personal data occurs as meaning the transfer outside the European Economic Area. In other words, to third countries. I won't go into deep the GDPR and its coverage, the binding corporate rules, how you practice GDPR, but I would like to address that under PDP law, as a rule, transfer of the personal data abroad can be carried out with an explicit consent of the data subject. So explicit consent is required. However, in person to the Article 9, alternative methods of transfer abroad without the explicit consent is regulated through a different method. In this alternative method, the transfer abroad might be carried out without the explicit consent if the legal conditions for the processing exist. So what are those legal conditions? Again, I won't go into deep that much, but they're all written in the Article 9 of PDP law. The data controller is expected to confirm two issues and act accordingly for the transfer abroad without the explicit consent. The first one is the data controller must confirm whether there is an adequate protection in the country of destination. Unfortunately, at this point, the Turkish Data Protection Board is expected to publish a list of countries with an adequate protection. However, such a list is still not published, and in parallel to this, Turkey is not on such a list of any country. So, under the circumstances, any transfer abroad should be considered as a transfer to a country without adequate protection, which introduces the data controller to the second issue. The data controller must sign for the second option. The data controller must sign a commitment for adequate protection with the receiver of the personal data and submit this commitment to the board for its approval. During the review of the board, there should not be any data transfer, which is particularly almost impossible for the ongoing operations of the data controller. Very recently, the board has published a decision regarding the acceptance of a commitment for adequate protection in it was on February 2021 for the very first time. The decision was followed by another affirmative decision, and the board, if we would met for this webinar 2 months ago, I would have told you that the board is radio silent regarding the commitments for adequate protection. Nevertheless, the decisions do not include any details for us to benefit from. We also have little to almost no information on how long the consent process before the board lasted for these decisions to be made. So it is hard to predict clearly regarding the frequency and the direction of the future decisions of the board on this matter, unfortunately. Thus, obtaining explicit consent is still the current practical method for the transfer of personal data to abroad. There is also an important decision which I could not skip to mention, which evaluates the transfer of personal data abroad without fully establishing compliance with the PDP law. The board have concluded in this decision that the controller, who is the Turkish subsidiary of Amazon.com, Amazon Turkey, acted against the PDP law by transferring personal data without explicit consent, while its application regarding the commitment for adequate protection was still pending before the board for its review. The board has imposed a large amount of administrative fine only for the lack of accurate explicit consent on this data controller. Clearly, the lack of accurate explicit consent is considered as in compliance with PDP law in terms of not ensuring the security of the personal data by unlawfully transfer of the personal data data abroad. I believe that the data controllers must continue to obtain explicit consent for transfer of personal data abroad, even if they filed an application regarding the commitment for adequate protection before the Turkish Data Protection Board. Obtaining explicit consent is the legal way of transferring data abroad until such application is accepted by the board. I am also aware that there is an effort for converging the data protection practice in Turkey to the GDPR rules and applications. As a clear example, in April 2020, the Data Protection Authority in Turkey published an announcement regarding binding corporate rules. In this announcement, it is recognized that the standard methods for transferring the data abroad could fail to satisfy the functional needs of especially multinational companies in terms of data transfer between the same. Although binding corporate rules are not clearly mentioned in PDP law, this announcement was the intent of the authority to comply with GDPR practices. Until now, I spoke about the current application of the transfer of personal data abroad under the applicable legislation, which I accept it's a little bit challenging. The good news is, in the economic reforms package, which was recently announced by the Presidency of Turkish Republic, the PDP law will be amended by taking the provisions of the GDPR regulating cross-border transfer of personal data into account. I have to say that this declaration is still very comforting when considering the challenges faced by both the Turkish and foreign data controllers who are subject to the PDP law. Now, I would like to ask to Günce, would you please evaluate the PDP law practices in banking? What are the challenges that the banking industry is facing, or what are your other comments on the practices of PDP law in the banking industry?
Sure, thank you very much. Thank you for the valuable information. Indeed, it is very challenging to work as a lawyer in a global company, having the data protection law, which is fairly new in Turkey. Well, for many years, we have only been dealing with client confidentiality clauses in the banking law. Actually, as you know, the data protection law is very newly introduced, so we have to comply with it, which, you know, being a global bank, we already have some practices, and now for the last couple of years, we have been implementing data protection law as well in Turkey. So, I mean, the main thing is normally the clients, they don't just trust us only with their money, they also trust us with their data. Maybe data is even more valuable than the money because it is becoming more valuable each day when we have this digital world. In banking or in ING Bank, we have to consider how we should use or keep the personal data. So right and legitimate use of legitimate purpose, using data in the right way and for the legitimate purpose is really very important. And we have to also use it for only required amount of time. So how we are going to, how are we implementing that in banking? What do we do in ING, for example? So first of all, we have to have a end-to-end control of the data flow from receiving the data and deleting the data. So we have to control the journey of the data within the banks. How do we do it? We have data owners, which we call data subjects, those are mainly the business departments or other data owners in infrastructure department heads or their teams. They are the owners of the data, so they are responsible for keeping the data safe, keeping the journey of the data, say from the very beginning to very end. So we keep them responsible. What do we use? We use technology for data protection. What we have is, for example, we have data leakage program, data leakage prevention system. I cannot send a personal data email, an email that includes personal data outside of the bank without my manager approves it. So if I send such an email, it goes to my CEO, and then it is quarantined. It goes to my CEO, and after only he releases it, then my data goes outside. That's how data. That's how the DLP system works. So we don't only report the data leakages, we also quarantine them. So we prevent them from going outside. This is one of the examples. We also keep the quotas. We have an AI technology who controls download of personal data from systems like KKB, like credit bureau systems. So we use technology, but technology is not enough, because data protection actually begins the desk of an employee. So they have to be aware what they can do, what they cannot do. We started 2 years ago, we started classroom trainings, which ends a very difficult exam. Unless they receive 80%, they wouldn't pass the test. So they had to receive the training. So I think we covered 70% of our employees with classroom trainings, and 95% of the employees received online training. They received emails, they receive videos on awareness. I'm happy to I happily experienced in the last couple of months that people really started asking very difficult questions. Like, they understood what data protection is. They're asking questions which are, is it against the law or not against law? They are right now, experiencing the gray areas, which means they already know what data protection is. They're asking questions where, some exceptions are happening. I'm very relieved when I hear that questions, which, gives me comfort that at least they're very aware what data protection is, what data is. So again, what we are doing is we should do, and what we are doing is we have to do future-proof programs. Yes, we have the technology, our people are aware, but data is increasing in the banking. We have, every day we receive hundreds of new clients, couple of new products each month. So we have to do the control tests each month. Maybe every 6 months we have data inventory checked and rechecked. We have policies which repeats control of this programs which we already have. Obviously, data protection does not only for the bank lines, also for our employees. We are a global bank, as you just mentioned. We cannot release the data to our global systems, even for training purposes, even for human resources purposes, to global systems. We received from each and every employee explicit consent in order to release the data to outside systems. So it was a big challenge. So I think that's all for now, unless you have any other questions on data protection and banking.
Thank you very much, Günce. it was very helpful for us to picture the situation in practice, in a daily life, in a business life. So thank you very much for your remarks. You mentioned the future-proof of programs. So it reminds me the legal tech area. Newly developing technologies digitalize the many products, services, and individual activities in our daily lives. Even Günce mentioned what's going on in a bank. This digital transition process, without doubt, affects commercial activities as well. In many industries in which business is carried out in conventional ways, they have to shift their practices to digital environments. The pandemic has also changed the legal industry's relationship with the technology for the better. The legal industry is not where it should be when it comes to the use of technology, but when it comes to 2020, it's been pushed to the industry forward. Legal industry is also known as legal tech, is defined as software and technology which is used by the law firms or the legal teams, the in-house lawyers to facilitate their processes and improve their effectiveness. So with the help of the pandemic, now we are now in a new era. There are several main types of legal software that include everything from in-house legal action products to social discovery tools. Each subset of legal technology serves our specific use cases within the legal industry. Turkey has already a significant experience in legal tech area due to the use of the automation. With the emergence of disruptive technologies such as bots and bot-based tools, the blockchain technology, and the artificial intelligence, AI, entrepreneurs and software developers have started to take action in order to develop fast and less costly technologies to meet the needs of lawyers. There are many factors driving this development, from big data to artificial intelligence and analytics. Legal tech market is highly diverse, reaching out to many fields such as legal analysis, online dispute resolutions, contract reviews, contract automation, machine learning solutions, and document automation, and etc. Legal tech has achieved different levels of development and relevance, depending on the country where you are. I would like to tell some examples that we find. For example, there is a British startup called Luminance that provides an effective platform for works of any language or any jurisdiction. It is a brilliant AI program and a machine learning algorithm to make document analysis extremely fast and productive. Also, there are some other practices in the governmental areas. For example, for a long time, Estonia has been using the e-file system. Also, again, Estonia has a pilot AI judge system. Said AI is capable of making autonomous decisions with more common court procedures and tasks, and that would take hours of human judges' work. The Estonian court system operates with one of the lowest budgets per capita in the entire European Union right now. Some other examples are in Canada, the Canadian Minister of Digital Government launched the federal government's directive on the automated decision making. It's another digital hearing workplace example. It is still a pilot project, but it will come somehow, sometime. Also, there are examples in United States, like Utah Supreme Court's program for the regulatory sandbox pilot system. I will not go into deep, but looking at Turkey, we may give some examples of the emerging technologies based on e-signature applications, also the legislation mobile applications, legal search engines, legal forums, the e-justice system, duty lawyer applications, e-collection, and finally the e-hearing application are amongst the legal tech developments in Turkey, mainly on the governmental area. The majority of these softwares have been developed taking lawyers into consideration. There are also softwares such as Turklex, which systematically access the current legislation, the judicial decisions and precedents through an artificial intelligence. Another example is Adalet Hanım. It's again a software supported by artificial intelligence, which analyzes the cases, interprets it, and provides results. It also provides assistance in petition drafting and documentation, such as the e-lawyer. So now it's today's legal tech, and also there are risks on this legal tech applications, but we need to discover them so that we can prevent those risks. What's happening on the European Union side? On the European Union, they took an important step regarding the regulation of legal tech. As you can all guess, the European Commission for the Efficiency of Justice of the Council of Europe adopted a charter on the use of artificial intelligence in the judicial system. So now again, Günce, I know that you have been awarded at least twice regarding designing a legal tech platform. So you are very familiar to all these kind of legal platforms. So I am eager to learn the details of this legal tech platform that you have been awarded. Would you please give us some details?
Thank you. And thank you by saying at least twice. We only received twice, but I would like to receive more.
I'm sure it's on way.
Well, I have a wonderful team, so it's their success. When I joined ING 3 years ago, I think that was the best decision. One of my best decisions was appointing and head of innovation and manager on innovation to my team. He's a lawyer, and he has a team that deals with not only legal support but also innovation. We started a project called Digital Legal. Digital Legal is now ING branded. It's an ING brand, registered brand. So under Digital Legal, we aim to automate and digitalize our processes, because in banking and in a global company, we have a lot of processes in the legal department as well. So we wanted to automate it. because what I always say is, you know, my lawyers are very smart, so they shouldn't repeat what they do every day. So they should be, they should act as innovators, business partners. You know, they shouldn't repeat things that they always do. Having that in our pocket, we started producing new technologies. 2 years ago, we received Innovation Award, Global Innovation Legal Award, on a platform called Legon, Legal Online. Legon is our own tool, which we respond our internal clients through this system. Normally, what we do is we give legal opinions, right, in documents or by email, etc. Normally, we do it by email, but whenever a lawyer leaves the bank, or the other party does leave the bank, we may lose the data, and it doesn't really happen to become a library when you do it by email. So we created a platform called Legon. On Legon, it is our internal clients ask the question through Legon, and we respond them through Legon. They have a list of headings, titles. Is the question related to letters of guarantees? They click on the type of the question, so we can have them in our library in a very neat way. So we have headings like, is the question related to attachments? Is the question related to guarantees? So they choose their subject. This way, we are able to create reports on what subject we received the question. What is the content? We obviously have frequently asked questions. So when we have this library, so they ask questions, we respond through Legon, that creates a library. And the library also, this platform also reports to us what branches asked what questions on what subjects. We were able to create our own chatbot that uses that information as a library. Right now, our chatbot is a dummy one, but we are working on having an AI type of chatbot. So we are very proud of that. So even we will not have to respond the question that is repeating by a real lawyer. So the chatbot will respond that. The second award we received was Legate. It is the litigation system. Most of the big institutions, they have their claims and lawsuits in an Excel files. We created a platform where we have regulatory and legal claims in that system, and this system reports to our global systems, so the finance department knows what is my litigation risk in Turkey automatically in 5 minutes. So it is up to date, and it receives data from the ministry, from the Justice Ministry. We actually started doing it from UYAP. Data comes to our system, and our system lists the claims for us, and our Legate puts it into the standard levels of pages, and it creates the report for our global systems. So it's a very user-friendly system. And for Legon and Legate, our ING Global decided to use it in the future for other countries as well. And we have a new project. It is called e-Scientist. It is about electronic and digital signature. So we are going to do our signing of the internal documents like employee documents, etc., vendor documents, and also at the very end, client documents through this e-Scientist system. We are still working on it.
Wow,
So
brilliant.
those are what we have done and what we are planning to do in the very
I
near.
mean, it doesn't sound like it's a in-house legal department. It sounds like it's an R&D department. Wow, how many platforms did you design? 3, 4? I couldn't count.
Right now we have 2 platforms, and the third is coming. It is e-Scientist, this electronic and digital platform. Right now we have 3 platforms to work on.
Bravo.
And we are, of course, we are developing it every year. IT people are our best friends, so I always make the joke, we feed them with chocolates and coffee and they work for us. They're really good friends, and you know, we are working together as innovators.
Yeah, yeah. It's like an R&D club.
Yeah.
The lawyers and the IT people. So it's called legal tech.
Yeah.
So you mentioned briefly the turning this rapidly changing environment into a vision. This reminds me the change in technology, and with the pandemic, the change, the habits, all shopping habits, all habits have been changed. Even the grocery shopping has been shifted to online platforms. So since we started the change in the banking industry, I would like to continue with the fintech and the fintech regulations. How does it happen? Of course, the companies and namely the banks want to keep customer satisfaction at the front, at the forefront, and started to benefit greatly from the artificial intelligence technologies. As Günce mentioned, it's not only in-house, it's also for their customers, and increase their applications for profiling, which offers personalized recommendations to its customers. In the face of current situation, which also resulted in customers spending more time in the virtual environment, it can be stated that we have experienced a period in which electronic commerce was perhaps the most powerful and widespread during the pandemic. As another result of the impact of the pandemic, there have been increasing awareness amongst consumers regarding the contactless technologies. Of course, maybe it started only for health issues, but when the digital transformation started, you cannot stop it. The digital transformation can be clearly observed with the examples such as mobile banking or QR-based and contactless payment systems, and even the cryptocurrencies. To meet these expectations, works regarding the fintech industry and the competition in the fintech industry have increased in Turkey as well as worldwide. In this period, the COVID-19 card payment methods have been replaced by contactless card payments, and the QR payments have been increasingly common through mobile contactlesses. Payments through the loyalty programs based applications are turned to more application used programs. New generation continuous financial experience applications, which also manage the main business of the SMEs, also constitute an important step in the financial technologies. Previously, the financial experiences was maybe the experiences of the big companies, but today it is also reachable for the SMEs. Technology companies combine their technological strengths with their financial strengths to aggressively expand in all industries, including finance, especially companies such as Google, Amazon, Facebook, Apple, called as GAFA in US, or but Baidu, Alibaba, and Tencent in China have made significant breakthrough in this regard during the pandemic. This rapid pace of technology developments has started to have positive results, such as the decrease in technology costs. In line with these developments, it can be stated that the financing provided to fintech has increased significantly in the last few years. According to the Startups Watch's latest global fintech report, dated November 2020, fintech startups has collected a total of 2.3 billion USD investment through 150 deals. It's huge. In the current situation, both governments and regulators recognize fintechs as the evolution of financial services and proactively support them. However, regarding certain issues, it can be stated that the regulation has been left incomplete or is too strict. At least in Turkey, it's the situation. When it comes to the regulations, it may be said that less is more. So it's like salt. It's advised that you use less. Here is the important issue that the regulations are applied in a manner as to support the fintech industry. In this respect, especially in Europe, regulatory bodies are focused on fintech initiatives that have been approved in a controlled manner. However, when we look at the United States, both technology companies and financial technology companies are supported for said companies to achieve global growth. Again, when we look at the European Union, back again, with the Payment System Directive 2, PSD2 regulations, it is aimed to promote competition and innovation by the way of allowing access to customer data to third parties with open banking and promoting both competition and joint action between the banks and financial technology companies. On the other hand, limitations and governance for the use of personal data are defined within the framework of the GDPR. While GDPR provides limitations, PSD2 attempts to define freedom on the basis of the payments. With the adaptation of PSD2 directives in Europe, the way for API banking has also been paved. In this way, startups can reach the potential to offer faster, more reliable, and flexible products to consumers by means of APIs that are opened up by the banks. I am of the opinion that as a similar regulations commence to be implemented in Turkey, a big progress will be made in the fintech ecosystem. Looking back to the Turkish financial industry, it's a very strong industry and a very effective factor for the financial technology ecosystem to be a vibrant and fast-growing structure is being a very strong industry. Turkish financial sector and banking system is one of the powerful aspects of Turkey's economy. The young and dynamic workforce in the country, and especially talented human sources allocations in the technology, finance, and banking industries, have an important role in the rapid growth of the fintech ecosystem. Of course, what we have to do is we need to support the fintech ecosystem with the regulations, maybe without doing over-regulation on the fintech ecosystem. Looking at the legislative developments in Turkey in 2020 in the banking industry, of course, Günce, I'm sure, will mention some of those. I would like to count some of them. The ability to use digital identity in the banking services is one of them. The other one is the digital and remote execution of identification and contract processes. It is again very, very important. Requiring Turkish QR code standards to be applied when using a QR code. And in this context, assigning the task of operating the QR code routing system is another important step taken in 2020. Another important step was the instant and continuous transfer of funds system, which was supported and developed by the Central Bank of Republic of Turkey. The entry into force of the regulation on banks, information system, and electronic banking services by the Banking Regulation and Supervisory Agency may also considered as an important development in 2020. So, what signals does the regulation give us for the period and for the upcoming periods? First of all, regarding the issues brought by the regulation, which I have just mentioned, banks should take the necessary harmonization actions in the context of important updates should be made in the infrastructure of the said organizations and information systems. In addition, the top management of the banks will now have to closely follow what needs to be done in the field of information systems and information security, and the sharing of customer data with fintechs, with the open banking. Apart from the exceptions in the banking law, the consent of customers must be obtained to share confidential customer data with the third parties in Turkey or also in abroad, of course. Therefore, banks completing their adoption process in line with these changes will be among their priorities during 2021, I guess. Especially with the developments of the open banking. For example, in the upcoming periods, I am of the opinion that we will make progress in subjects such as single point access to all bank accounts, receiving investment advice through a virtual assistant, wallet management for cryptocurrencies such as bitcoins or other currencies, the introduction of personal finance management features. So I'm sure we will see that in the near future. In this respect, it is possible to say that we will get the positive results of these developments throughout 2021, and new developments will follow them. At the current stage, it is now more critical than ever to determine strategies regarding developing technologies and to render the correct action plans, especially for banks and financial institutions. It can be said that the biggest reason behind this is the rapid growth of non-bank institutions. In this respect, I am assuming that the payment institutions and e-money institutions, maybe called as fintechs, will be the priority agenda of the banks in the upcoming periods. Now, I want to invite Gönce to remark on her technology vision and developments and activities in the field of law. What are your activities and supports of ING in the field of law, and what are your personal remarks on technology vision and developments in the banking industry?
Well, thank you very much. Actually, as you said, the future is open banking, that's for sure. You know, it's like last couple of minutes, I believe, so I will try to quickly summarize what's happening. As you know, the call centers, you know, mobile banking, we used to call them alternative distribution channels, right? It was alternative distribution channels. Right now, it is not alternative, it is the main channel of banking. You know, obviously in the pandemic time, people even, you know, bank clients that are not at their 20s or 30s or 40s started using mobile banking much more than ever. So as I said, it has become the main channels of banking. So we are, as ING Bank, and most of the banks also are very into developing their mobile systems, mobile internet access. What's happening in banking? First of all, the new regulation, and there is one regulation that has passed, there is another draft regulation. It makes digital client onboarding possible, which means that you will not have to go to a branch to open an account. You will be able to, we will be able to, as a client, open an account by a remote means of using technology. What will happen? We will, as you know, we have in our Turkish ID cards, the new ones, we have this barcode. We will take the photo of the barcode, and with the near field communication system, the bank systems will be able to understand that this is a new ID and the biometric means of the ID. And then there will be a video call with the bank personnel, between the bank personnel and the client. Then in maybe 10 minutes, the client will be onboarded to the bank. After that, it is very easy for them to, because the authentication means has passed, they will be able to start doing their, you know, transfer of money, usage of any banking products, etc. This is now possible under Turkish law. Another another development in banking sector, we will be able to now doing the remote advice. So it is remote advice, meaning we will have digital bankers. It doesn't mean robots. It will still be, you know, bank personnel, but the bank personnel will help the client with their products and with their transactions only remotely. We will be able to do it on a video instead of them calling the bank or coming to the branch. So it's called remote advice. And very newly, as you mentioned, government started taking some measures, and they just explained what's their vision on digitalization in Turkey. One of them is digital banking license. So it is a new type of banking license. These banks which receive digital banking license will not have any branches. It will be entirely digital bank. We don't know the details yet, but we are very excited about it. So those are the things I want to mention. Obviously, you know, there are other regulations going on, but those are the main standards that we have right now.
Thank you very much, Günce. To sum up, the digital transformation, which I've been taking about for a long time, has gained rapid momentum with COVID-19, I guess. So we are still trying to cope up with this new transformations, either which industry we are in. Even as a lawyer, we need to adapt this new transformation. We are end of the session and end of our time. However, there are a couple of questions that we have received from the chat box. We don't have much time, but maybe there is a question about due to the recent change in Turkish law concerning cryptocurrencies, is it possible and advisable to open a crypto AMI bank there? So this is something that we did not mention. Maybe we can talk about a bit on the crypto banks or cryptocurrency transactions. Would you like to remark on this question?
Yeah, well, it is actually the answer is no. There is no regulation in relation to crypto money or crypto transactions or custodian of crypto money in banking. So, or sale or purchase or transactions of crypto money in Turkey. So we don't have any regulation in there in relation to that crypto money transactions.
So not only the banking regulation and supervising agency, also the Capital Markets Board of Turkey and the Financial Crimes Investigation Board has not announced any decision about the cryptocurrencies yet. But soon, I'm sure we will see a kind of at least a draft regulation about cryptocurrencies.
Sure, or a concept or a vision, but nothing right now.
Nothing right now. Yes. Any other remarks that would you like to put or?
Well, thank you very much. This was I learned a lot, and also I was happy to mention what's happening in the banking industry in the technology side. Well, we are happy with the developments in the digital world, but it never beats meeting in person. So, of course, we should only use physical meetings maybe in our social life, but the business life will go on digital. That's for sure.
Right.
Thank you very much for inviting me.
Thank you very much for being with us today. I think we are end of this session. So then.
Yes. Thank you very much. Thank you very much, Çiğdem, and thank you, Günce. I think we can all agree that was, a really fascinating webinar with a lot of great insight. I'd firstly, of course, like to thank on behalf of Mondaq, our wonderful panel, SRP-Legal, Çiğdem and Günce for their time and expertise. And I'd also like to thank you, our audience, for joining us today. If you did send in a question that wasn't answered, do not worry. Çiğdem and Günce will be more than happy to follow up with you. I hope you all have a lovely rest of your day. Goodbye.